My name is Rose Kerbick, and I'm a director and co-owner of Accountant Online. And you're very welcome to this morning's webinar with Robert Dixon of Mason Hayes and Curran. So we asked Robert to come along to talk to us because many of our clients have plans in the future to secure funding from a VC or an angel investor. And most of us don't have experience of what that process looks like. Robert knows it very well. So he's going to be talking about categories of investment, stages of a deal, negotiating points, and timelines. And I'm here to monitor the chat. So the benefit of being on the live event this morning is that you get to ask your questions directly and have your answer straight away. You need to leave, don't worry about it. We'll send out a recording later, and we'll also send on Robert's slides and contact details. So thank you, Robert, for joining us again. Please do let us know how are you going to begin? What are you going to be telling us today? And you're ready to start.
Yeah, absolutely. And thank you very much, Rose, and everyone at Accountant Online for asking me to do this particular talk on the anatomy of an investment. I think it's obviously a very relevant topic to anybody who's considering taking in investment into their business, or indeed is in the throes of it or on the cusp of it, I suppose. So it's, as I say, it's part of what I do for a living. I'm a corporate lawyer in Mason Hayes and Curran, so we see the ins and outs of this, and understanding how it works, I think, is very important as you go into it, and that's what I'm hoping to speak to people about today. So I suppose that the things, Rose, and stop me at any point with any questions or
Sure.
or anything that drops into the chat there. So for me, I think going into it, for people knowing the deal process is very important. And I'll gear this at, I think, a lot of the people who will be attending or will watch this on the video afterwards.
Yeah.
Be folks who are taking investment as opposed to investors. So we'll look at it from that point of view. But I think for somebody taking investment, it's important, if you haven't done it before, to know what the deal documents are, to understand what we mean when we're talking about due diligence, what's involved with that. Separate to that, then, what's the disclosure process and what do you have to do, what do you have to tell the investor about, what documents do you have to give them, and what's the legal status of everything. And also, what are the market trends? Obviously, having that bit of antennae of what's going on in the market. Is it really hot for investment at a given point in time? I suppose just being plugged into the media a little bit, but also talking to people in the space there is very important. So there are a few things we'll cover today. And I think the first and very obvious question that I touch on in my slides here are, what do you actually require? What amount do you require for investment? Sometimes you could take on more than you need, but that's less of an issue generally. So what do you need and why? Nobody's going to invest if they don't understand what you need the money for. It could be for general capital expenditure, of course, but it's good the more you can show what you need it for, the better. And I've said there in the kind of green rectangle there, sufficient runway. So what we're talking about there is runway for the business over a period of time. So the amount of cash you'll need in a year's time. There are a lot of fast growth businesses that get into a situation of constantly fundraising, and there's no issue with that. You finish one fundraiser, you're almost immediately thinking about the next one. But particularly in this market where it's a little bit more challenged than, say, 2021, it was a frenzy. But you kind of want to be not having to go straight back for the next investment. What runway do you need? What amount will you need to bring you through a period of time, maybe the next 2 years? But obviously that'll vary depending on the situation. You want to be thinking about debt or equity. So equity investment is somebody coming in for a percentage of the company, really owning a percentage of the company if they put in a euro sum. And there isn't a debt obligation where you have to pay them back. They own a share, I suppose, of any dividends that would be theoretically paid out. And then if you come to sell the whole business, they get their percentage of that. Whereas debt is different. The debt provider doesn't have an actual percentage ownership in the business, but instead you have to pay them back, of course. And so that's less attractive in some, you know, if you know you're trying to grow the business and it's perhaps not hugely revenue generating yet, for example, then the ongoing obligation to repay debt may not be attractive, but then you get away from dilution. So it just depends on the situation, really. And then, as I say there, the orange box or red box, acceptable level of percentage dilution. So you have to think about that. Obviously, what are you valuing the business at? If you're taking in €2 million investments, are you valuing the business at 10 million post money? In which case it's a 20% investment. So what dilution are you prepared to live with? What can you justify? Can you show a valuation? Can you justify a particular valuation that you have in mind?
Yeah. And
then types of investments. So, and when we talk about an equity investment, that's for shares as opposed to debt. Somebody can invest for ordinary shares, which are kind of normal, what the founders will typically have. You're talking about the normal voting rights, equal split in dividends and all the rest. Whereas preference shares give the holder of the preference shares first dibs, if you like, on an exit. So first dibs on the amount that they put in plus whatever depending on the terms of the preference shares, it might also be a percentage each year, accruing each year on top of that the holder of the preference share will get that amount if that's everything that's available on a liquidation or on a sale. So it's a slightly, as long as you get voting rights, preference shares are obviously better than ordinary shares, and will be typically or will often be insisted upon by an investor as the type of shares they want. And then if you want to go down the debt route, or that's the option that's on the table for you, traditional bank or alternative debt providers are there. Everyone knows what debt is. Convertible loan simply means that you're putting debt in, but the holder of that debt has the right to convert that into shares. And then finally, debt with security. This is something we're seeing more in the market in the last year and a half. Given the difficulties in the tech market, sometimes if a debt provider, alternative debt provider, that sort of thing, puts debt into a fast-growing company, they will also look to take security over the assets or the shares of the company. So it just gives an extra layer of protection to a lender, and it just depends what your negotiation position is, whether you have to accept that or not.
And what would that look like? Does that look like shares or?
Well, it wouldn't. I mean, typically, if it's just debt, it's a loan into the company with repayment obligations. And then when you have security, all that would mean is if the borrower, which is the company or the business, fails to repay that debt, or also if certain events of default, perhaps in the debt documents, are triggered. So you're getting into layers of complexity there. But basically, if you don't comply with the facility agreement, then there's an ability for the lender to come in and enforce under the security. Now, what that security is, again, is an open question. It may be over, like at its most aggressive, it may be over all the assets and shares of the company. So you just have to be very careful what security, when we talk about security, you're right, Rose, to ask, like, what does that mean? It can be pretty onerous. And I've seen situations where deals have fallen over because of it, because a lender is looking to take security over everything. The debt might actually only be for a small portion of what the company's total value is. So you don't want to go there as a business owner, unless you have.
I'm just thinking you really want to know all of this well in advance before you need the money. So you know what you want, because it can be very attractive to take an offer of money when you need it.
Yeah, completely agree, Rose. I mean, I think and this sort of thing hopefully is useful for people just to get that sense. And I think talking to people who've been through the process, and I'll get to that as well, just around different reports that are out there. There's a great ecosystem there in Ireland. So it's really important to understand it and not feel you have to accept something necessarily that doesn't smell right.
Yeah.
But sometimes,
You can get caught up in it and
get caught up. Now there will be situations,
Yeah.
and I understand there's different circumstances where
Yeah.
sometimes you just need the money and it's a risky investment maybe for a lender who will therefore insist on things. So there are different circumstances for sure.
Yeah.
And that's, I mean, I talk about finding an investor, but that goes to the point you just made as well, Rose, about understanding the process. So I've said here, engage in the fast growth community. So that's the ecosystem I was talking about, the different type of, support entities that are out there. I've talked about Enterprise Ireland there, who would be, very good for, whether they're actually investing or not, whether they're their stake, they have various different, various different processes you can go into there, but it's a very good source of information in any event. Be familiar with bodies, I've said there, such as the IVCA, that's the Irish Venture Capital Association. There's a whole, all of the members there, if you can go onto the website, are investors, they're at different stages, venture capital, private equity. So it's a very, very good, again, just like Enterprise Ireland, it's good to be au fait with these things and find what's
happening. For them to know you as well, I suppose, and know which one might be a match for you.
Sometimes it's individuals, you just, you gain a relationship, somebody can be really, like a lot of people out here in these organizations, they actually are very much willing to help somebody who's driven and trying to grow their business. So really, it's really useful just to try and gain these relationships and arm yourself with as much understanding and knowledge as possible. And as I said here, talk to others who've raised investment and get advice. That's key as well. So then really we move beyond the stage where you're thinking about raising money and you're thinking about the type you might like to raise. And then we're preparing for the investment is what I've said here. So data room due diligence documents. So it kind of depends. There's no one correct answer here, but I would say if you get to a point where you've kind of agreed a term sheet or you're agreeing a term sheet with an investor and you're going to raise a sum of money, whether it's 1 million or 2 million or 5 million, there are likely, and again, particularly in this market, some investors might be slightly more cautious than they were in 2021. And that may not always be the case, it just depends. But there will be questions. They will want to know information about your business before they put their precious money into it. And that's where having your documents and having your information about the company quite well prepared is important. And often the place you put that would be a virtual data room. Now, there's all sorts of virtual data rooms out there now that you don't have to pay for, or they're very, there's other ones that you do have to pay a lot of money for that might not be attractive at a certain point. But it's being organized is the point I'm making here. And suddenly you come into an investment and you're asked a pile of questions and you've no idea where your documents are and stuff isn't signed. That's just not a good start. So having an organized data room, even if it's Google Drives and things like that, that's fine. And the due diligence documents that will be asked for, having them there is good. I've said here, understand the deal process. We'll get into that a little bit more in a minute, but do understand it in advance. Think about what's important, your key deal red line issues. If you do have any, is there anything, and talk to your advisors, but what do you care about in the deal? What do you not want to give away in terms of negotiating rights before you get into seeing what the other party wants? Think about what you need or want. Then there's some key things that won't be a good start if you don't have them sorted. Every company is required to have a register of members, which is actually the record of who owns the shares. And it's something that sometimes slips by a lot of early stage companies where it's just doesn't seem to be necessarily part of the education process in some of the different supports that are out there, or people just don't seem to realize it's really key to have that, because that's the record of who owns the shares. And so housekeeping like that, you want to make sure the intellectual property is invested in the company. We see that as well. Sometimes there's a funny situation where a contractor there was no agreement in place, or the intellectual property might not be held in the place it should be. So there's a few basic things like that it's not the message you want to be sending to an investor when they start looking into their due diligence. So things like that. Types of investor now, that's preparing for the deal. But just to say again, there are very different types out there. And sometimes, as I say, depending on your situation, it may be you may not have a great choice. But if you do have a choice, it's worth being aware of this. Sometimes at an early stage, we see what's referred to as a friends and family fundraising round. So friends and family kind of that might wish to invest and take a stake in your business. Other individual investors, there's kind of plenty of high net worth individuals around Ireland that do invest in kind of fast growth Irish businesses. So that certainly does happen. Then strategic investors who might make sense from your point of view. You know, if somebody can sit on the board who's experienced in what you're doing, that they can advise, they can open doors for you. That might be a reason to take, you know, to take investment from somebody. Then you get into venture capital, you know, and there's venture capital firms here in Ireland, there's, you know, abroad and so forth. And again, they're, you know, they will be very experienced in the financial side of things, you know, in terms of how to help grow the business and create profit, but they will also be demanding for sure. So slightly different. They may have requirements that some of, you know, the friends and family type investors
mightn't have.
But they might actually drive your business along as well. And also it's a case of where in the journey you are, because you will typically not raise a huge amount in a friends and families round, whereas, you know, the venture capitalists, the private equity obviously have deeper pockets and you're getting into larger rounds then at that stage. Then there's banks if you're going in terms of debt, but then some banks even have kind of equity arms to them. If you look at AIB and Bank of Ireland, so there is that type of equity fundraising option there. Alternative lenders increasingly in the market. So obviously, again, you have to watch the terms there, but it's, you know, that they will provide debt, but they're kind of venture debt, that sort of thing. And you think then about international and domestic. For some businesses, it makes a lot of sense to have, for example, a US venture capital go in, because that will open doors in the US, or there might be a particular reason, or there might be more options. And then sometimes it might make sense for a corporate to invest, or a business. So that's not private equity or venture capital. They're not engaged in a particular sector, if you see what I mean, or they're not. Their business is investing and making money from those investments. And whereas for a corporate, you know, they might buy up or might invest in your business, and that might open doors within that corporate, which may be a customer, for example. So there are different reasons, different types of investors out there. The stages of an investment are really, we talk about anatomy of an investment. This is really at the heart of it. So there's preliminary and term sheet, where you're negotiating the key terms of the deal. The term sheet won't be binding, but it should set out the key deal items. Due diligence, where the investor is looking at is looking at your documents and so forth in the business, and just ensuring that they're happy to invest, but also perhaps looking at where they might need protection in the documents, that sort of thing. Document negotiation is the terms of the deal itself, the binding terms and the documents, and then completion is when the deal actually becomes binding. So they're really the four key stages of an investment. They don't kind of go necessarily one after the other. You typically have the first one, preliminary term sheet, without the other bits happening. And then due diligence and document negotiation, you would hope would happen at the same time. But in some instances, some investors will want the due diligence stage at least very much underway or largely complete before they get into the documents, because it can be unhelpful to kind of negotiate documents, then realize there's a big smoking gun in your due diligence that you then need to get protection on. So.
And Robert, you're going to take us through each of these. Are they what is a term sheet, all that kind of thing?
Yeah, I will. I mean, in terms of going through the documents, I will. You know, in a minute we'll go through the different slides. Conscious, some people will have. There'll be some participants on the call who this is second nature to them, and some perhaps less so. So and people can ask any questions as well.
I have a question for you.
Sure.
Actually, it's kind of a, you know, it's a live question, a practical one. So Siobhan has said that she's a sole director of a limited company with 100 shares. She'd like to bring in another director and give them 20 shares or 20%.
Okay.
And a non-exec 20 shares. So she would have 60 shares or 60%. What's the process and how much would I expect to pay?
What's the process and how much would she expect to pay? So I suppose the question there is whether, well, first of all, as a purely practical matter, is she going to transfer existing shares that she has, or is she going to allot new ones? It sounds like she's considering transferring them. I mean, on a basic level, if you different people take different approaches to this. The basics of actually just signing a stock transfer form for 20 shares and signing a stock transfer for another one for the other 20 shares and a director appointment letter and the CRO, that's all very, very basic and cheap.
Yeah.
The thing that different people take different approaches to is how much you want to protect your rights and so on. So if you're transferring 40% of your business, essentially that's a big amount. And what happens then if a week later somebody resigns as a director, but they've no obligation to transfer back the shares? And then equally, in terms of running the business going forward, what are the rights and obligations that the different parties have? So that's where you get into the question of, do you create a shareholders agreement? Now, some people don't want to create one at this stage because it's a little bit of, you have to negotiate it. But I think others certainly take the view that they do want to. Certainly, in terms of the point I just made, is quite an important one. And are they permitted to compete with the company?
So the least expensive part of the whole thing is allotting the shares. We have
allotting the shares.
Accountant Online would do it very frequently, but we wouldn't get involved in the shareholders agreement or why or how it's happening. But I'm sure you would see people, you would give advice to people on doing a shareholders agreement and perhaps what the obligations of those shareholders have and what they might be bringing. So I'm sure Siobhan has thought of all of those things, but nevertheless, that's the point. The least expensive is the allotment of the shares. The more expensive or more onerous is really sitting down and thinking, what is it you want from these shareholders in the future and what their obligations and
particularly
contributions might be.
If they leave or they compete with the business, what happens then? Do they have shares?
Not something you probably want to think at that point, but
but it's obviously a sticky situation to get into. So
it's harder to get out of.
Even a short agreement that kind of deals with some of those issues is probably wise.
Thanks.
Okay. So legal due diligence for investments we'll talk about next, and I'll get into the deal documents kind of separately. Term sheet is one, but what we typically see when there's going to be an investment is a legal due diligence request list, which is a fairly standard set of questions. In some instances, for a smaller investment, you might see a curtailed one, but I suppose it's just being able to answer these questions quite easily. What we see sometimes is a questionnaire like this, which is fairly standard, is produced, and then it takes a long time for the business or the company to answer it, and you can really stall momentum if you're not ready to answer that. So one thing a company can do, and again, I'm conscious people are so stretched, and it all takes time, but just maybe try and get a standard due diligence request list in advance, so you're not completely shocked by the questions, and are able to answer them, and have the documents ready. I'd say is important. Talked about the data room. I would say again, don't start preparing one, when it's too late or when it's going to cost a month of delays. In which time everybody can get out of bed and change their mind, and suddenly the deal doesn't seem so attractive to someone. So you want to really be ready to go through the gears. So what I'd say is get your data room, and you can probably do it from an early stage. Get that Google Drive or whatever it is. get your documents organized into one place. And I mean, you know, your contracts that you have in place as a business, you know, register of members, all the key things, just have them there. And it's very good for housekeeping in all sorts of ways, never mind an investment. So actually having that level of structure, but I understand in a fast growth business, everything can be frantic. So I get that it's not always easy, but just from the point of view of executing an investment, it's really, really helpful if you can do this.
Any recommendations on where you'd get a good like sample legal due diligence request list, or would you just Google it and find it there?
I think it probably has to be from a lawyer. If we obviously have them, but if so, happy to talk to people if they have a reason, we can certainly chat to them. That's one of the things we can. I've said here striking the balance. So just watch. Obviously, we've talked about the data room. If you've signed a term sheet with an investor, what we sometimes, you know, and you get into due diligence, there can be a little bit of cat and mouse in terms of trying to, you don't want to, some businesses, there can be very sensitive information in some of your contracts. So you just want to get the timing right of disclosing some of that. And there's no exact science to it. It's a judgment call, but you might not want to, deals do fall over even after a term sheet has been signed. So you want to be careful about when you disclose that information, and perhaps do so late in the day or redact. You know, you can black out certain sections if you need to on price or customer names or something like that. I've talked about the register of members. Make sure your company's registration office filings are up to date. That's the first thing an investor or its lawyers can check publicly. And if the first thing you see is the annual return hasn't been filed and it's out of date, you know, the company's in the process of being struck off because of that, it's not a good start either.
No, not a good look.
Not a good look. So just keep on top of your CRO filings, governance and board minutes. Just again, be aware, you know, every company, even if you only have one director, you know, that you are supposed to keep board resolutions. You're supposed to, there are different things as annual general meeting. There's things like that I think are probably overlooked some of the time, and it's just again, it's a little it's not the right impression you want to give. And just to continue on that, your contracts, are your customer supplier contracts in writing? Are they solid and binding? Is there an ability for all your contracts to be terminated? I mean, listen, different businesses work in different ways. Sometimes a lawyer on the kind of investor side will come in and all these things, you know, the fact that all your customers can actually terminate their contracts easily is an issue. But I think people understand that different sectors work in different ways. But the main thing is to just have a solid record of what your contracts are. If they are in writing, or if they aren't in writing, which can sometimes be the case, and there's just an arrangement in place, you need to be able to describe that, so that it's not sort of a mystery that people are trying to piece together. Employment agreements, are there any? You know, and are they written? If so, are there any existing shareholders agreements or investment agreements, grant agreements, anything like that will be asked about. Data protection. You know, it's been a topical issue for the last number of years. So just be aware of what the GDPR does require you to do. I think 100% compliance is very, very difficult sometimes, to be perfectly honest.
Yeah.
But being able to show, again, it's some of these things are giving an impression, giving a positive impression that, you know, on the one end of the scale, you've never heard of GDPR and aren't doing anything as a business about it if it's relevant to your business, but it generally will be, versus going over the top. So just having some level, some modicum of an attempt to have a GDPR policy and try to comply is important. Then you've got environmental, social and governance. That's kind of a big hot topic at the moment, to be honest. So what are you doing as a business about ESG? Again, just being able to speak to that, because it'll be one of the things that investors are hot on, I suppose. And then intellectual property. In a standard tech investment, I suppose, and there are different businesses I'm conscious on here, But what intellectual property due diligence will they do? That I suppose it can be very basic, really, but this is where it can be a proper red line issue if there's a huge IP issue. You just need to watch this, that you know, any registration that should have been done, that there isn't some infringement, that the IP isn't actually owned by some contractor and not by the company. So this is an area that you just want to have a certain understanding of. Make sure that, I mean, the key point to make here is, at law, if somebody is an employee, any intellectual property that they create in the course of their work will be vested in the company. But if you're a contractor and there's no agreement in place saying that the IP is owned by the company, then it won't automatically be owned by the company. So you have to make sure that that agreement is in place, the IP assignment agreement, or something in the contractor's contract. To be perfectly honest, it's great if it's a fancy, you know, agreement drafted by a lawyer, but actually something is better than nothing.
Okay.
A piece of paper that says that just any intellectual property created in the course of the contractor's work is owned by the company. Like, even that signed is honestly can be the difference between millions of euro down the road. And otherwise, we've seen it in cases. So that's a really important point to take away. I said I'd come to the deal documents themselves. The term sheet, sometimes called the heads of terms or heads of agreement or letter of intent. It should be non-binding, non-legally binding, apart from a few provisions in it like confidentiality and things like that. It should set out the key terms of the deal, because what you don't want is to get into really detailed documents and then realize there's some headline issue between the parties on what percentage they're getting or what the class of shares is, or something like that. Be careful what you sign up to in a term sheet. If there's parts in it you don't understand, you should get advice at that stage, because although it's not legally binding, it does have moral authority, and it's very difficult to actually row back later in the deal on what you read in it. Then the investment agreement is the agreement under which the investor agrees to pay X to the company, and the company agrees to allot Y amount of shares in consideration for that, really. And that will include things like warranties and the terms of the deal, which I'll get to in a second. The shareholders agreement is a bit different. Now, you can combine the investment agreement and the shareholders agreement, but the shareholders agreement is kind of different. So it's kind of a future-looking agreement, if you like, that says, okay, if following this investment you have a 60% shareholder here and a 30% shareholder here and a 10% shareholder here, what will their rights and obligations to each other be? So I suppose that's the question there. Constitution, and as I say, there is no legal requirement to have a shareholders agreement. There is a legal, like every company has a constitution. It's just a question of how detailed it is and what it says in it. So there will be a constitution. Then employment service agreements will sometimes be put in place during a deal, and then the disclosure letter. So in the investment agreement, the company and sometimes some individual founders will give what's called warranties, typically to the investor, which are statements of fact about the company. So to give one example of a warranty, there is no pending or ongoing litigation against the company. Very simple terms. Your disclosure letter discloses any exceptions to the warranties. So even if the company knows that there is a piece of litigation, for example, you give that warranty under the investment agreement, and then you disclose in the disclosure letter, actually an exception to that warranty is that there's this piece of litigation. So that's what the disclosure letter is. So those are, you know, you won't always see exactly the deal documents having exactly the same names, but that's the essence of what they are. You won't always see an employment service agreement, but that's what you need when there's an investment. Key negotiating points and deal terms. First point we mentioned on the first or the second slide, what percentage will the investor actually get? You know, so they put €2 million in, what percentage of the company will they own after that? I've talked about warranties, statements of fact about the company that the company gives, and if any turn out to be incorrect, that aren't disclosed against, then there's a claim or a potential claim by the investor against the company.
In the future. Yeah.
In the future, exactly, when it turns out to not be true.
Mm.
Indemnities are slightly different. So warranties are these generic statements of facts about the company.
Yeah.
An indemnity is slightly different. So an indemnity is if an investor, through its due diligence, finds out about a particular problem, say, okay, well, I'm still willing to invest, but if this particular court claim results in a loss to the company and succeeds, then I want to be able to claim under this indemnity on a euro for euro basis. Now, I have to say, indemnities are much less common in investments. We see them all the time on mergers and acquisitions where there's a purchase of a company, but it's less common for investments. Secondary purchase and deferred investment. So I've talked about an investment of money into a company where you get a percentage of the shares. A secondary purchase is slightly different. So as part of these deals, sometimes it's less common at a fast growth stage or early stage, but you do an investment of several million into the company, but at the same time there might be a founder that says, listen, as part of this, I'd like to sell a small portion of my shares, take some cash off the table. And that's what the secondary purchase is. So that can sometimes happen as part of deals, which can be attractive, obviously, to founders. And then deferred investment as well. So sometimes if an investor is coming in, they might put a sum of money in, but say, I'll put more in when X, Y, and Z happens. It might be a milestone for the business. And then you get into a quagmire of whether the warranties are going to be repeated. But that's getting into that detail.
Yeah.
Non-competes. So what an investor will sometimes want if they're investing in a company, they will want to know that the founders are not actually running another business on the side that competes with the business they're putting their money into, or even in a direct way that they won't compete. And also, if a founder one day wakes up and says, I'm not doing this anymore, leaves the company, that they can't just set up a competing business the next day. So they'll often look for that. And equally, if there's a number of founders, you might want to protect, an individual founder might want to protect their investment in a similar way. Then there's veto rights. If you're investing as a shareholder, what is the company allowed to do without your consent? And then what percentage consent is needed? It can get a little bit complicated at that stage, but it's basically the idea to be aware of is that if certain actions, a list of actions, need shareholder consent to be done. Anti-dilution. So a shareholder will. We're not talking here about further investment for shares in the future, which is a positive news story for everyone, because it grows the overall pot. But what a shareholder will be very sensitive about, and this is very topical, is if I put in €2 million or €3 million into a company tomorrow, for a 10% stake in the company, and I've therefore paid, for the sake of arguments, €10 per share that I get. I don't want next year some other investor coming along and getting to buy shares for €8 a share, because then that will dilute the value of my investments. So sometimes what you see is provisions, and there's a fair bit of media about it, anti-dilution provisions around a down round happening. So it's different. Again, you get into different types that can happen there, but it's just one of the deal terms to be aware of. And then drag and tag. Drag and tag is kind of to do with the sale of shares. Drag along rights are where a certain majority can force the others to sell if there's an attractive offer. And tag along is the opposite. So if I'm a 20% shareholder and everyone else is going off and selling their shares, that I'm allowed to participate in that at the same rates and same price. And some more then. So information rights. If I'm, investors will want information. They'll want quarterly packs, things like that, or more regular than that. They may want a board seat, and that just depends on the situation. Or they may want an observer right, which is kind of it's not a director, but it's somebody that can attend board meetings and so forth. Preemption is either sale of shares or issue of new shares, or both. So a little bit different to what I was saying there about anti-dilution. But if I'm a 20% shareholder in a company, what preemption means is that if the company says, right, we want to raise another €5 million here, I will have a right as a 20% shareholder first up to put in 1 million of that 5 million so that I keep my percentage. And if all the other shareholders say, right, well, we don't want to actually participate, then I'd have the right to put the full 5 million in. Obviously, it's easier said than done because you have to, as an investor, then have the money to do that. But it basically means that you can't be adding new shareholders to the cap table without without first giving an opportunity to the existing investors to invest.
Yeah.
And the same thing when you're selling shares. And again, it depends on the terms of the documents. Liquidation preference I've mentioned earlier, but that's just in some instances, it's an investor getting first dibs on any money that's available to be distributed up to a certain amount. It's not that they get all of it, obviously. It's just that they get the amount of their investment plus possibly a percentage per year after the investment. I've said here any provisions as to underperformance. You wouldn't see this commonly, and it's quite aggressive, but it's something in a kind of difficult market you'd see more, where an investor kind of insists in the deal documents on having certain rights in the event that a certain growth hasn't happened or certain milestone targets haven't happened, and they may have an ability to appoint additional directors or that sort of thing. I've said here, are you happy with the proposed shape of the board? So the deal documents will also set out who has the right to appoint directors. So that's something you have to watch. Is there an independent chairman? Are there advisors? Are you in the, does it make sense if you're a 60% shareholder? Do you have the right to appoint the majority of the board? So you want to make sure that you don't accept something that isn't proportionate or fair. And I've talked about intellectual property, so you may have protections about that in the documents. Disclosure process. So I've talked about that a little bit in terms of the warranties. So warranties, to repeat again, they're the statements of fact about the company that you find in the investment agreement. And then the exceptions to that are set out in the disclosure letter. Some will be general disclosures, which are kind of anything that's found on the company's registration office, for example. And then specific disclosures are, per the example I gave of the litigation warranty, the specific disclosure would be, actually, there is this one particular case. Different definitions of disclosed can be found. So that's just what's in the investment agreement. So you just have to watch what that actually says. And there's one kind of trend towards general disclosure of the data room, which means that each warranty, if the data room is generally disclosed, each warranty would be qualified by what's in the data room. As an investor, obviously that's very friendly to kind of any founder and so forth. If you put things in the data room, you might want to ensure that they qualify the warranties. You will have a stronger leg to stand on in trying to insist on this if you have a well-organized data room with a clear index. If you have a disorganized data room, it's going to be very hard for an investor to accept that. And generally investors will resist this, but it just depends on your negotiating position. And the disclosure bundle and cross-reference to the data room, basically when you're doing a disclosure letter, then you also refer to a pile of documents, what's called the disclosure bundle, but you should be able to cross-refer to the data room as long as it's well organized.
Robert, in the data room, would you put your board meeting minutes for the last year, those kind of things? Would there be that level of detail in there?
Absolutely, yeah. That would definitely be there. And I think you just want to sense check everything that's going in. If there's something very sensitive at a point in the deal that you're not confident that the investor is, I don't want to say serious, but that they haven't shown enough for you to know that the deal is more or less going to happen. You might just certainly read the minutes before they go in. Now there might be just nothing you're worried about there, but just be careful with that. But absolutely, Rose, I would. That's the type of detail you want to see in there. And again, this is where the due diligence request list I mentioned. So all of that will be covered in that. They'll be requested, and then you have to provide them. So it's via the data room. So I think that's all I wanted to cover. In conclusion, the key pieces of advice are: prepare really thoroughly. And that doesn't mean, because it will suck your time.
Yeah.
It's obviously worthwhile. It's how you scale your business and grow your business. But be prepared for that. It's a big investment of time, and you don't want it obviously to interfere with the management and development of the business itself. Engage suitable advisors. Obviously, might sound a little bit self-serving, but you just have to, if you don't have somebody, a lawyer, for example, who's actually experienced in doing these deals, then it creates a deal execution risk. And there just mightn't be the resource to keep the momentum going on the deal and to advise you and get it done quickly. And also just know what points not to care about or push back on, and be able to say to you, there's no point having a fight about that point. They just won't accept anything else. So prepare thoroughly. Understand your key negotiating points. Maybe sit down before the deal and say, actually, there's just these two issues I care about. Or even it can be very useful later in the deal when you're in the thick of it to come back and say, okay, when I look back on it, these were the only things I cared about, and I was fine about that. So you can get quite bogged down in things that maybe weren't that important at the beginning. And actively maintain deal momentum. Somebody has to do that. The worst thing that can happen is a deal just drifts, and then people get sick of it and it's away. So you have to drive it forward. So that's one thing I would definitely say is important. And nobody, if you're a founder with a majority stake in your business, nobody's going to care about this deal as much as you will. So you have to really drive it. Don't sit back and wait for somebody else to do it. But just get the right people around you, and hopefully you can get the right investor that you have a good relationship with, and it'll take care of itself. But do be proactive. That's all I'd say.
Robert, that was so clear. All of that. I know it's technical in a way, but it all makes sense. So I'd just like to invite anybody with their own particular questions to send them in the chat. I realize also that this can be really sensitive, and you may not want to put your own personal questions into the chat. So do follow up with Robert later. We've got Robert's email there. And my own questions while we're waiting for any other chats are, Robert, like, it sounds to me, business owners are going to be really busy all the time running their business. So well in advance of wanting to sell, you want to be setting up the documents that are appropriate for the data room and have those sort of part of your habits as administering your business, I imagine.
Yeah, I would definitely say that. And I think that's far easier. Listen, there's different personality types out there. Sure. And some people just are very talented in many ways, but actually getting organized like that mightn't be the way they operate.
You might want a wingman or woman to support you in that.
That might be it, actually. And that there are priorities, but certainly you're right, Rose. That's the best way of doing it, because actually trying to find something when you're suddenly under pressure is very difficult.
I have met a lot of business owners also who have regretted perhaps taking money because they left it too late to be looking for money, and then they took the money, and of course, as somebody described, it might have been you, but if somebody described, one of our advisors, look, it's like getting married. You really need to be very careful who you're getting tied in with, because you're really tied to these investors for a few years at least, which can be a long time to be uncomfortable. So your relationship needs to be very good. And if you're anxious about the money and the cash flow in your business, that's not a good basis for tying yourself to somebody who has money. It's not a good, although it's very attractive to do it.
And it's definitely, I've seen situations over the years where there's been kind of a difficult negotiation and unreasonable demands being made, and clearly a challenged relationship during the negotiation. And it doesn't tend to get easier afterwards. To be
really? Okay.
It can depend, but like the worst outcomes have actually sometimes come from those bad negotiations as well.
Okay.
And if a particular type of investor insists on certain things in the documents, it's not just there for window dressing.
Okay.
Things that looked like, oh, well, that surely they wouldn't actually enforce, where they actually have enforced it. So it's
Okay.
just, you're right. And sometimes, Rose, of course, there's a situation where you just need to go with what's there, and that's understood. But you're absolutely right. The more planning you can put into it, and the more you can understand your options and look into it early before there's a kind of a desperate need, as you say, then you'll be in good shape, and hopefully you can you can then have the options you want and have the right partner to go forward with.
Yeah. But Robert, I find that really, really clear, and I hope everybody else did too. So I encourage any of you to get in touch with Robert. You've got loads of experience in this area, and I know, Robert, you don't mind meeting people early in the process, when they may come back. They may have an initial meeting with you and come back to perhaps a year later when they're more prepared, but you can set them on the right path, certainly.
Yeah, and I've seen that a lot, and it's absolutely fine. We know that's the way it works, and you know, and sometimes timelines with it can change as well. But absolutely, I do think that's the right, you know, whether you have somebody else or whether it's myself, I do think that's a sensible way to go. Make sure that you're prepared and you've got the right people, and that isn't just on the legal side. Obviously, it's talking to different types of advisors, obviously, or experienced people, just so you understand what the process is and who you should be speaking to. Yeah,
and it's really about matching, isn't it? It's about So thank you so much, Robert. Thank you, everybody, for joining us, and do come along to our next webinar, where we will be talking about HR. And if that is of interest to you, there's a lot of changes happening in 2023, and getting the basics right is still a priority. So that's on the 25th of January. So I look forward to seeing you then. Thank you, everybody. Thank you, Robert. We'll hope to have you back again soon.
Thanks, Rose. Thanks, everyone.
Thank you. Bye now.